On April 9, 2025, two federal agencies filed charges against the same man on the same day. The Securities and Exchange Commission filed a civil complaint in the Southern District of New York. The Department of Justice filed a criminal indictment in the same court. The defendant is Albert Saniger, founder and CEO of Nate Incorporated. He raised over $42 million from investors by telling them his app used artificial intelligence to process transactions. According to the SEC and the DOJ, it was false. The SEC did not call it a marketing mistake or exaggeration. They called it fraud and charged him under the anti-fraud provisions of the federal securities laws. That is what AI washing enforcement looks like. And if your company has ever told investors that you use artificial intelligence in a pitch deck, in an offering memo, in an earnings call, this episode is about the legal framework that now governs that language. Nate launched in 2018. The concept was straightforward in its ambition: buy anything from any e-commerce site by opening the app and tapping buy. The app would handle the rest. Saniger did not describe it as a promising prototype or a work in progress. He described it as a working system. He told investors the app used AI, machine learning, and neural networks to complete purchases automatically. He used the phrase, like magic. Nate ran two formal fundraising rounds, from at least the spring of 2019 through December 2022. Saniger presented Nate's capabilities in pitch materials to investors who were being asked to commit real capital. Over $42 million was raised across those rounds. Investors were not buying a concept. They were buying a capability claim, that the automation worked, that the AI was operational, that the technology behind the pitch was real. That distinction between a concept and a capability claim is where this case begins. According to the SEC's complaint, the Nate app did not use AI to process transactions. According to the SEC's complaint, orders placed through the app were rerouted to overseas contract workers who manually completed each purchase exactly the way a consumer would, clicking through checkout pages by hand. Saniger claimed automation rates above 90%. The SEC alleges the actual automation rate was essentially zero. That is not a measurement dispute. It is not definitional hair-splitting. The SEC alleges Saniger knew the app lacked a functional AI model and continued to present fabricated metrics to investors. Even after Nate began incorporating some technology, automated bots intended to handle checkouts, the SEC's complaint documents that those bots crashed and failed at minor website changes. The capability that investors were told existed did not exist at the level described. In June 2022, a news expose cast public doubt on Nate's AI claims. After that report, Saniger was unable to raise additional capital. The company ceased operations. It formally dissolved in January 2023. Investors who funded those rounds were left with losses when the company dissolved, and the SEC's complaint documents the gap between what they were told and what was operating from the beginning. The SEC didn't charge Saniger because his AI underperformed. They charged him because the anti-fraud provisions of the federal securities laws treat a material misrepresentation to investors the same way, whether the lie is about revenue, about inventory, or about whether your technology actually exists. There is a category of securities law violation that gets called a disclosure violation, a failure to include required information, a technical omission, a formatting problem, serious but remediable. That is not what the SEC charged here. The SEC charged Saniger with violations of Section 10B of the Securities Exchange Act of 1934 and Rule 10b-5 thereunder, and Section 17A of the Securities Act of 1933. These are the core anti-fraud provisions of federal securities law. They are the same statutory basis used in the most consequential securities fraud prosecutions in U.S. history. Anti-fraud liability under Rule 10b-5 requires a material misrepresentation made in connection with the offer or sale of securities with scienter. Scienter means intent or recklessness, not negligence, not optimism. The SEC's complaint alleges Sanagar knew the app lacked a functional AI model and continued to tell investors otherwise. The materiality standard is the critical element for every executive watching this. A fact is material if a reasonable investor would consider it important in deciding whether to invest. For a company whose entire value proposition is AI-powered automation, the accuracy of the AI capability claim is not a footnote. It is the investment thesis. When an AI capability claim is material to the investment decision, and for most AI-forward companies it is, that claim is no longer operating in marketing territory. It is operating in anti-fraud territory. That is the line the SEC's complaint articulates, now drawn in the official record of the Southern District of New York. The SEC also seeks a permanent officer and director bar against Sanagar. This is not a fine that a company absorbs. This is a personal consequence that follows an individual, permanently. An SEC anti-fraud investigation is not a review of whether your technology worked as well as you hoped. It is a forensic reconstruction of the gap between what you said and what existed. The SEC's framework requires three elements: a material misrepresentation, or omission, made in connection with the offer or sale of securities, with scienter, intent, or recklessness. Each element has a documentation trail. For Nate, the SEC's complaint documents pitch materials containing specific AI capability claims, product demonstrations that Sanagar allegedly staged, instructing Nate engineers to be on standby to complete test purchases manually during investor demos, claimed automation metrics of above 90% presented to investors, and actual operational data showing the automation rate was essentially zero. The evidentiary architecture is simple. Compare investor claims to operational reality. That gap is the enforcement theory. What the SEC alleges constitutes the fraud. Sanagar also allegedly fabricated success metrics, not adjusted them, not rounded them, fabricated them. The SEC's complaint is specific about this, claiming above 90% automation when the rate was essentially zero is not a measurement methodology dispute. It is an allegation of deliberate misrepresentation. The SEC didn't need a whistleblower. They needed a news expose and a performance gap. The June 2022 article didn't create the fraud. It revealed the documentation trail that had existed since the first investor pitch in 2019. On April 9, 2025, the same day, the SEC filed its civil complaint. The U.S. Attorney's Office for the Southern District of New York filed a criminal indictment against Albert Sanagar. The DOJ charges securities fraud and one count of wire fraud. Each charge carries a maximum sentence of 20 years in prison. The DOJ also seeks forfeiture of all proceeds derived from Sanagar's offenses. This dual-track enforcement model is structural. The SEC establishes the civil liability, the anti-fraud violation, the investor harm, the injunctive relief. The DOJ establishes criminal culpability, the intent, the scheme, the punishment. These two agencies operate in parallel. The wire fraud charge deserves specific attention. Wire fraud is implicated when a scheme to defraud is executed in whole or in part through a wire communication, which in 2019 through 2022 means every investor email containing an AI capability claim, every pitch deck transmitted electronically, every Zoom presentation in which automation metrics were presented. This is not an abstract legal theory. Every investor communication that contained a material misrepresentation and was transmitted electronically is a potential wire fraud predicate. For executives who approve investor communications routinely, this is the exposure that most legal reviews are not currently pricing. Sanager resides in Spain, according to reporting by Holland and Knight, citing the case docket. As of July 2025, the SEC had not yet been able to serve him with the complaint, and the DOJ indictment remained the only filing in the criminal case. No scheduled hearings, no pending motions. The actions are live. The process is underway. The legal exposure does not require service to exist. The practical question for every executive and counsel watching this: what specific language creates anti-fraud exposure? The materiality standard provides the answer. A statement is material if a reasonable investor would consider it important in deciding whether to invest. The inverse is also true. Not every AI reference in investor materials is a securities law issue. The safe zone, aspirational language that is clearly identified as forward-looking, accompanied by appropriate cautionary statements. We are developing AI capabilities that we expect to improve transaction processing. With proper cautionary framing, is forward-looking projection. It is subject to the PSLRA safe harbor. The exposure zone, specific operational capability claims presented as current reality. Our AI processes transactions automatically, stated in the present tense, without qualification in a document designed to induce investment, is a present fact representation. If it cannot be substantiated by actual system performance, it is within the anti-fraud perimeter. Nate's claims were operational present tense assertions. The app processes transactions. Using AI, automation rates are above 90%. These were not projections. They were capability representations that investors relied on to make capital allocation decisions. For every executive who has approved the phrase AI-powered, AI-driven, or AI-enabled in an offering document, an investor update, or a pitch deck, the question is not whether your AI exists. The question is whether the capability description is accurate as a present fact representation, and whether you can substantiate it against actual system performance data. If you cannot answer that question confidently, you are operating inside the enforcement perimeter this case defines. When an SEC enforcement action is filed, the first call is typically to the D&O carrier. Directors' and officers' liability insurance exists for regulatory actions. The premium was paid. The policy was in force. That is what it was for. But there is a category of findings that D&O policies are specifically structured to exclude, and the Sanager case sits directly inside it. D&O policies typically contain intentional acts exclusions. Some contain conduct exclusions that activate upon a final adjudication, or even upon a regulatory finding, of intentional misconduct. When the SEC invokes the anti-fraud provisions of the federal securities laws and alleges scienter, not negligence, not oversight failure, but deliberate misrepresentation, the coverage analysis changes. The sequence that follows: SEC files anti-fraud complaint alleging intentional conduct. D&O carrier receives notice and reserves rights. If the SEC obtains a judgment or a settlement that includes a finding of intentional fraud, or if the DOJ secures a criminal conviction, the carrier may deny coverage based on the intentional acts exclusion. The executive who assumed the D&O policy would respond was pricing a disclosure violation, not an anti-fraud finding. Different risk profile, different coverage outcome. The corporate indemnification structure compounds this. Most state corporation laws prohibit companies from indemnifying executives for intentional fraud. When the anti-fraud finding is made, the corporate shield that would otherwise cover legal fees, settlements, and judgments may not be available. Personal exposure becomes real. The CFO who signed investor communications. The board members who approved the fundraising materials. Each is individually positioned inside the exposure architecture when the anti-fraud provisions are invoked, and the coverage analysis follows. The D&O policy was purchased. The premium was paid. The question is whether the policy was purchased for the risk that actually materialized, an intentional fraud allegation, or for a different, less severe version of regulatory exposure. The Sanager case is not an isolated enforcement event. It is the third distinct tier of a documented escalation arc that regulators have built systematically over 18 months. March 2024, the SEC settles simultaneous enforcement actions against two registered investment advisors, Delphia USA Incorporated and Global Predictions Incorporated, for making false and misleading statements about their use of AI in investment processes. Total civil penalties, $400,000. The SEC established the enforcement category and the precedent. January 2025. The SEC charged Presto Automation Incorporated, a formerly NASDAQ-listed public company, the first AI washing enforcement action against a public company. The SEC found that Presto made misleading statements about its AI speech recognition technology, failed to disclose that the technology was owned and operated by a third party, and misrepresented the degree of human intervention involved. The enforcement perimeter expanded from advisory firms to public companies. April 2025, the SEC and the DOJ filed parallel civil and criminal actions against Albert Sanager, founder of a private company, for raising over $42 million through AI capability misrepresentations. Criminal exposure added. Parallel prosecution model activated. Advisory firms. Public companies. Private company founders. Parallel criminal prosecution. The escalation arc is clear. In February 2025, the SEC created the Cyber and Emerging Technologies Unit, the CETU, with a mandate to focus on combating cyber-related misconduct and to protect retail investors from bad actors in the emerging technologies space, including fraud committed using emerging technologies such as artificial intelligence and machine learning. This is not a temporary task force. It is a standing enforcement unit with dedicated resources and a formal mandate to prioritize this category of misconduct. Acting U.S. Attorney Matthew Podolsky, announcing the Sanager charges, stated that the DOJ and FBI will continue to pursue those who seek to harm investors by touting false innovation, because, in his words, this type of deception not only victimizes innocent investors, it diverts capital from legitimate startups, makes investors skeptical of real breakthroughs, and ultimately impedes the progress of AI development. That framing is significant. Regulators are not treating AI washing as a narrow securities violation. They are treating it as a market integrity problem, one that damages not just individual investors, but the broader capital allocation ecosystem for legitimate AI companies. The CETU was not created to investigate one case. It was created because the SEC determined that AI washing is a systemic market integrity problem. Systemic problems require standing enforcement infrastructure, not ad hoc task forces. Here is where the Sanager case stops being about one founder and starts being about institutional governance. The board of a company does not build the technology. They are not the engineers. They are not reviewing the code base or running the automation benchmarks. But in most companies raising private capital or maintaining public market disclosures, the board approves the investor communications that describe the technology. Under the anti-fraud doctrine applied in this case, the question is not whether you understood the technical architecture. The question is whether you approved a material representation to investors that could not be substantiated. 3 categories of board-level exposure are now implicated by this enforcement theory. First, approval of investor communications containing AI capability claims without a verification process for those claims. Second, Absence of a governance mechanism requiring technical substantiation and legal review of AI language before investor distribution. Third, failure to disclose material gaps between claimed and actual AI performance, particularly when internal information raises questions about the accuracy of investor-facing descriptions. The governance implication that follows is direct. AI capability language in investor-facing materials, pitch decks, offering memoranda, earnings scripts, board presentations prepared for prospective capital sources must now be reviewed as a securities disclosure, not as marketing copy. That means materiality analysis, verification against actual system performance data, and legal review before the document leaves the building. One additional point that the Sanager case makes explicit. This analysis applies to private market fundraising, not just public company disclosures. Section 10(b) and Rule 10(b)(5) apply to the offer and sale of securities, including private placements. The assumption that we are a startup, not a public company, so the securities laws do not fully apply, does not survive contact with this enforcement theory. Private litigation targeting AI capability misrepresentations has emerged alongside regulatory enforcement, creating exposure across both tracks for organizations and executives simultaneously. The enforcement perimeter now covers registered investment advisors, publicly listed companies, private company founders raising venture capital, and any executive whose name appears on investor communications containing AI capability claims that cannot be substantiated. Scam Beast investigates corporate fraud so you don't have to. What I have shown you today is not a cautionary tale about one founder's decisions in a startup that failed. It is the enforcement architecture that now governs every AI capability claim made to investors, across the private markets, across public company disclosures, and across every communication that travels by wire between a company and its capital sources. The SEC applied the anti-fraud framework to AI capability claims. The DOJ confirmed the same facts support criminal prosecution. The CETU has a standing mandate. The enforcement arc is documented, expanding. 3 questions this framework makes unavoidable before the next investor communication goes out. 1. What AI capability claims are currently in your investor-facing materials? 2. Can each claim be substantiated against actual system performance data, right now, not at some future milestone? 3. Has legal reviewed that language under a materiality standard, not a marketing standard? If you cannot answer all 3 with confidence, you are operating in the enforcement perimeter this case defines. If you want to understand the documentation failure that creates examination exposure before enforcement arrives, that is episode 13. If you want to understand the supervisory obligation architecture that regulators are using to evaluate your AI governance, that is episode 14. This episode is what happens when those gaps are not closed. This is Scam Beast. Subscribe if this kind of analysis matters to how you manage financial risk, because the next episode is already in the record.